So good morning, everyone, and welcome back to our weekly webinar series. Over to Anil, sir.
To Ankit, welcome to 128th episode of AAA weekly webinar series. We try to choose topics which are currently in vogue and currently are in need. So we have seen that there are many proceedings against personal guarantors which are presently being adjudicated by the NCLT and in some cases by DRT. And there are many questions that are not clear and where we get a lot of calls and WhatsApp. And we have also seen on various groups that clarity is required in many scenarios. So therefore, we chose to have this topic, which is a kind of mix on the procedures and the legal adjudication so far happened in the case of personal guarantors. We actually would like to have more and more questions so that we are able to clarify certain aspects of this personal guarantors insolvency and bankruptcy. So this is the objective. So Ankit, in case we try to see what exactly we are trying to understand today is what is the role of the RP during the insolvency resolution process, and what would be the role of bankruptcy trustee during the bankruptcy of the personal guarantor. Now, what we have seen is that like little bit of a kind of recap of the situation. The notification regarding the insolvency of personal guarantors, in fact, came on 15th of November 2019. And then it actually got challenged in various courts regarding the constitutional validity because it was differentiating individuals. One side is the individuals who have given personal guarantee and the other side of those individuals who actually have taken the loan. So the law was made applicable only to those who have given personal guarantee to a corporate loan. However, those who have taken the loan in their individual name, in their personal name, they were not covered under this law. Therefore, it was stayed by Honorable Supreme Court for quite some time. On 21st of May 2021, this judgment of Lalit Kumar Jain versus Union of India was pronounced by Honorable Supreme Court, and it was a combination of many petitions, including the petition of Anil Ambani. Now, then we also had another case, which is the Veerbhadra Industries Limited versus Axis Bank. That also came from Honorable Supreme Court, and some clarity was offered by this judgment. Now, another judgment which was very important from Honorable Supreme Court was Dilip B. Jeevrajka versus again Union of India. That was the judgment on 9th of November 2023. So now, after 9th of November 2023, most of the cases have started proceeding ahead. Many cases, the repayment plan is submitted. In many cases, even the bankruptcy process has already been started. So therefore, after 9th of November 2023, when we saw that this particular subject is now taking off, the personal insolvency resolution process of personal guarantors as well as the bankruptcy proceedings against the personal guarantors, that has now taken off. And in case you see, every day, many applications are listed for adjudication and many judgments are coming from NCLAT and NCLT with regard to the personal guarantors. So various scenarios are being addressed. One scenario that we actually, as we say, so all this, when we say like there is another judgment regarding the moratorium, and that was also very clear that once you file the application, there is a moratorium under Section 96 of IBC, and that moratorium is protecting the individuals. That moratorium is protecting the person against whom the uh, proceedings have started, maybe that he himself have started or somebody else have started. So this particular judgment was given by Honorable Supreme Court long back on 14th of August 2018 in the case of State Bank of India versus V. Ramakrishnan and others. Now, in this particular case, the Honorable uh, Supreme Court held that Section 14 of the IBC, which imposes a moratorium on the institution of suits or proceedings against the corporate debtor, does not extend to the personal guarantors. So that was the judgment when it was notified thereafter, and the court emphasized that the moratorium under Section 14 is specific to the assets and liabilities of the corporate debtor alone and does not include the personal guarantor. So that was the judgment when the personal guarantor was not given protection under Section 14. That was the judgment of the Supreme Court. Now, another judgment which is relevant to be mentioned here is from NCLAT, and that is from the Principal Bench, New Delhi, in the case of Dr. Vishnu Kumar Agarwal versus Piramal Enterprises. So, in this case, finally what was held and the legal issues in this case was whether the CIRP can be initiated against a corporate guarantor if principal borrower is not a corporate guarantor or corporate person. It was said yes, it can be, and that was regarding the corporate guarantor and personal guarantor. It is to different. You see, like that is one thing which is yes, it can be started against the corporate guarantor. If there are two corporate guarantors, it can be started against the two corporate guarantors also. So that was something which was there in the judgment. And then coming to the very important judgment was again Lalit Kumar Jain. And in the case of Lalit Kumar Jain, the judgment came on 21st of May 2021. So the important fact which was actually in the case of Lalit Kumar Jain, I would be just taking little time in the important issues in the Lalit Kumar Jain. So in this case, in the case of Lalit Kumar Jain, there were basically three things which was upheld. It was uh, pronounced by Honorable Supreme Court. One, that the Section 133 of the Contract Act, because it is uh, extending a personal guarantee to a loan, is a contract under Section 133 of the Contract Act. Now, the contract is between the personal guarantor and the lender, and the lenders, because of the resolution plan approval under IBC, the lenders have voted on that, and by just way of voting positively on the resolution plan, the contract of guarantee also changed without any kind of consent from the grantor. And therefore, the grantors were saying that that contract has actually been changed without our consent. So therefore, that contract stands negated now. So the Supreme Court held that to discharge the liability of surety on account of variance in terms of contract without her or his consent stands negated. The language of Section 31 of the Code makes it clear that approved plan is binding on the grantor to avoid any attempt to escape liability under the provisions of the Contract Act. So Section 31 of the IBC was used by the Honorable Supreme Court, and it was held that if there is any kind of changes in the terms and conditions of the guarantee because of resolution plan, that argument was negated only because of Section 31 in the IBC. Now, the second thing which was decided by this Lalit Kumar Jain was the sanction of a resolution plan and finality imparted to it by Section 31 does not per se operate as a discharge of the grantor's liability. That is the second thing which was decided by the Lalit Kumar Jain. And the third, which was important, again, it is similar, that the approval of a resolution plan does not ipso facto discharge a personal guarantor of the corporate debtor of his or her liability under the contract of guarantee. So this was the judgment, and this was a kind of opening of this new area of personal guarantors judgments. So this is something which is important. So therefore, in another case which is Dilip B. Rajka, give me a minute. I will just bring that case on my reading. So now coming to the one, yes, this is the case of Dilip B. Jeev Rajka versus Union of India. And in this case, the role of the RP was defined. In this case, it was very clearly said by Honorable Supreme Court that in the case of corporate insolvency, that is part 2 of IBC, that is corporate insolvency resolution process, CIRP, the RP plays a significant role managing the corporate debtors' affairs and exercising control over its assets. The RP can adjudicate certain issues and directly impact the resolution process. This is the CIRP, where the control comes to the RP, the management of the company comes to the RP, and also the control over the assets, and it can impact the resolution process. In the case of personal insolvency, which is covered in Part 3 of IBC, same judgment in the case of Dilip Jeev Rajka, it is said that the RP acts more as a facilitator, gathering information and recommending whether to accept or reject the insolvency application. That is the first role of the RP. When the RP is report under Section 99 of IBC, it is very clearly held by Honorable Supreme Court that the RP's role is only facilitator, only to save time of the court, only to gather information and recommending whether or accept the resolution plan or the insolvency application or not the resolution plan, I'm sorry. See, the RP's role is recommendatory rather than adjudicatory, lacking the power to take over the assets or make binding decisions. So the RP does not have any power to take over the assets of the personal guarantor, not even the bank account, not even any asset. RP's role is only facilitator, gathering information and recommending at the first stage when Section 99 is there. And then at the second stage, RP's role is only recommendatory when the RP is supposed to submit a report under Section 106 of the IBC. What is the role of the IBC? Even on repayment plan, the RP's role is to have a recommendatory role. Now, it was also held in the same judgment regarding the interim moratorium versus moratorium. The interim moratorium, which is defined in Section 96, says initially, automatically on filing of an application under Section 94 or 95, it stays legal proceedings concerning debt without affecting assets, concerning the legal proceedings and without affecting the debtor's assets. So there is no stay on the debtor's assets. So under Section 96, the interim moratorium says that there is a stay on the legal proceedings, recovery, and all proceedings where even the debt of the personal guarantor is being examined and being determined. Those are also called legal proceedings. However, the assets of the personal guarantor are not affected. He actually can sell, alienate the assets during that stay period. So then it is compared with Section moratorium, Section 14. It says in the case of Dilip B. Jeev Rajka judgment, the Honorable Court says that in the CIRP, more extensive moratorium comes into effect upon the admission of the application, impacting the corporate debtors' operations and management. Now, let us see finally the judgment. The judgment again, this says the court emphasized the distinct process under Part 2 and under Part 3, which the later focusing on the individual insolvency or the partnership firms. The role of the insolvency professional is primarily a facilitator or gathering information and providing a report, not an adjudicator. Interim moratorium serves to protect the debtor's assets but does not equate to full moratorium under Section 14 of the Corporate Insolvency. Natural justice. Now, the natural justice was actually upheld in this particular case, and even after this, the application under Section 94 or 95 cannot be admitted unless the other parties are also invited and can say whatever they want to say. So their say would be required in accepting an application under Section 94 or 95. Natural justice, regarding natural justice, the court held that natural justice principles are observed at the stage of adjudication under Section 100 when the adjudicating authority admits or rejects the application. Even when the RP gives a report under Section 99, the copy of the report is also supposed to be served on the debtor and the creditors, and they can also file their say in case they want to say anything or in case they have any objection before the adjudicating authority. Then finally, Section 95 to 100 regarding the filing of the application, regarding the moratorium, interim moratorium, regarding the preliminary report by the section report under Section 99, all Section 95, 96, 97, 98, 99, and 100, it was held constitutional. The court actually found there is no violation of Article 14, which is the right to equality, and also Article 21, which is right to life and personal liberty, that was also held as not violative. So the final decision was all the petitions challenging all these provisions like Section 95 to 100 was dismissed. It was dismissed, allowing the continuation of the personal insolvency. So this particular judgment finally triggered the process from 9th of November 2023. Now most of the applications are proceeding ahead, and this is the time when we are saying that yes, it is something which is very important, that the insolvency of individual personal guarantors, that is now continuing after 9th of November 23. Now, when we have now reached this stage, we also would like to see some of the judgments so that the questions which are coming in the minds of various colleagues and bankers, that actually gets resolved. On 5th of April 2024, NCLAT principal bench has given a judgment. That judgment says that in case there are 2 or 3 applications are filed differently, one application is filed by one lender and the other application is filed by another creditor, and both the applications are against the same individual. Both the applications are against the same individual. I will just see the name of the judgment, that is Mohit Arora versus IFCI Limited. The judgment is from NCLAT. It is the principal bench chairman's court, and the judgment date is 5th of April 2024. It says that if one application is admitted, there is no provision that the second application will also be permitted. In one case, the PNB Housing Finance also submitted an application that was admitted before, and the another application was filed by IFCI. So the NCLAT said there is nothing, that there is no possibility of appointing 2 RPs and starting 2 proceedings against one individual. It has to be one, and everyone else has to file their claim in that case. Now, so this is important because I don't know, there are some errors also by the lenders that they actually have one application, so they cannot file the other application. So the lenders may not have kept the track whether the other application is already filed or not, because the name of the individuals can be many. So in case there can be many Mohit Arora. So that is a error, but it is clarified that only one insolvency can be started against a personal guarantor. Another judgment which is from NCLAT, and again the chairman's court, which is dated 27th of February 2024. It is in the case of C.L. Sharma versus Bank of Maharashtra. C.L. Sharma versus Bank of Maharashtra, and it is regarding the role of the RP. Very important judgment, role of the RP, jurisdictional facts. So this judgment, NCLAT judgment, in fact, has referred to the judgment of Dilip B. Jeev Rajka versus Union of India. That judgment has been referred in this order of NCLAT, and it is held that the adjudicating authority should consider the issue pertaining to the jurisdictional fact at the stage of Section 100, and there is no adjudication contemplated at the stage when RP is appointed. Now, first is the RP appointment. RP is appointed under Section 97. Moratorium is given under Section 96. And then RP is supposed to file a report under Section 99. So when the RP was appointed, at that time it was challenged that this particular case, there is a limitation issue and RP should not have been appointed, and the limitation issue should have been seen at the time of initially giving moratorium under Section 96 and also appointment of RP at that time. Now, NCLAT says that this issue of jurisdiction or the issue of limitation, that would be seen when the order under Section 100 will be passed, that is the commencement of insolvency resolution process in the case of personal guarantors. When that starts, at that time, the limitation issue or the jurisdictional issue would be handled by the adjudicating authority. So the arguments that was being made before the appellate authority regarding the time barring nature of the debt, that would be only heard when Section 100 application would be filed. Also, it is very clearly held by the NCLAT that the RP is not precluded in any manner to submit a report regarding the limitation or any other judicial effect. When the RP is giving a report under Section 99, RP is not prevented. RP is also having that kind of power in case he observed any limitation issue or any jurisdiction issue. He can report under Section 9 to the adjudicating authority, and the report under Section 99 would be considered by adjudicating authority while passing order under Section 100, which is commencement of insolvency resolution process. Now, when the application is filed under Section 95, the documents are submitted with regard to the debt and whether the debt owed by the debtor, the creditor is time barred. It is all a related question, and the RP, while recommending the admission or rejection of the application, he can consider this. He is not prevented. He is not precluded from giving his recommendation on the basis of material which are on record. However, if that is not done by the RP, then the adjudicating authority at the time of passing order under Section 100 commencing insolvency resolution process can consider the issues of jurisdiction and the issues of limitation. Now, any defect in the application, and the question on appointment of RP does not require any consideration at the stage when the RP is appointed. It is held that in this judgment, insofar as the submission of the appellant that the adjudicating authority failed to take into consideration that authorization was not filed by the RP, it is always open for the applicant to take such or other pleas as permissible at the time of adjudication of the issue, including any defect in the application under Section 95, and the said question also does not require any consideration at the stage when RP is appointed. So therefore, everything can be adjudicated at the time of passing of an order under Section 100, but at the time of passing an order appointing the RP for the purpose of giving report under Section 99, all this is not required. So therefore, the RP will have to submit its report, and the RP's role has been elaborately examined by Honorable Supreme Court in the case of Dilip Jeev Rajka. So therefore, it is only a facilitator. So this is something which is, again, I wanted to say that this is an important judgment and it has come recently. Now, Ankit, we have another judgment from NCLT, and that is again principal bench from the chairman's court. And this particular judgment have already got dismissed from the appeal against this judgment has also been dismissed by Honorable Supreme Court. So this also can be said that this particular judgment has a Supreme Court stamp on it. Now, this is again Rahul Arun Prasad Patel versus State Bank of India. I just need a little bit of one moment time, and that is something which is right. So in this case, there is a kind of dispute regarding the signatures of the RP. So it is also a kind of very this also issues need a clarity. So in this case, the NCLAT very clearly said that there are two kinds of application. One is Section 94 application and then the 95 application. Now the applications can be filed directly by the creditor or debtor and also through a resolution professional. So if the so in case the Form C, which is prescribed for filing an application, it has four parts. It has four parts. Part 1 deals with the particular of applicant. Part 2 deals with the particulars of the grantor. Part 3 deals with the particular of debt. And Part 4 deals with the particulars and the declaration by the insolvency resolution professional. If in the bracket it is written, if application is filed through insolvency resolution professional. So the same application is filed. However, in case the Part 4 is signed by the RP, then it is considered that the application is filed by the RP. If it is not signed by the RP, then it is considered that the application is filed by the creditor or debtor. So this was the clarity given. So therefore, the Form A does not contemplate filing of a written consent with regard to the any application which is filed through the resolution professional under Section 95. It was thus not necessary to submit a written consent in Form A. So what is final now? That if the application is filed through RP, then there is no requirement of Form A, that is the consent of the RP to work as an RP. So that consent is not required. But in case that Part 4 is not, in case that Part 4 is not filled and is not signed by the RP, then consent in the Form A is required. Then consent in Form A is required. So this is also an important clarification, which is in fact was required in many cases. Now, some of the judgments which are like, there is a judgment from NCLT Chandigarh, and it is again a judgment on 12th of August 2024. This is like the judgment is Bank, Punjab National Bank and Indian Bank versus Mohit Indrayan. So in this case, the decision of the NCLT is the misuse of Section 94. Now, in this case, the Section 94 application is filed by the debtor, by the personal grantor, and that is pending before the adjudicating authority. Interim moratorium is also triggered. So during that period, a bank also files an application under Section 95. Same period, the application is also filed under Section 95. So the debtor, the personal grantor, argues that once the moratorium is started under Section 96, then the banks cannot file an application under Section 95 against me, because moratorium under Section 96 has already started, because I filed an application under Section 94, which is pending. Now, in this case, the adjudicating authority, Chandigarh bench, held that this kind of misuse of Section 94 is not permitted, and Section 95 application is filed by the banks. Therefore, that application is also at an advanced stage. So, therefore, Section 95 application, which was filed by the banks, that was admitted by the adjudicating authority. And Section 94 application is in any case will have to be rejected, because the one application can be admitted against a personal grantor, not two. So this was also one personal grantor tried to use the moratorium, and so that the application is as application of creditors is not considered, and it is delayed. Now, another application which is worth mentioning here is State Bank of India versus P. Raja Rao. This judgment is dated 22nd December 2022. So, in this case, is uh, the decision which actually came, like the bank, in fact, was having an OTS proposal from the corporate debtor. And the OTS proposal is normally considered as admittance of the debt. For it was held in this case by NCLAT Amravati bench that admittance is applicable only for the corporate debtor, not for the personal guarantors. If the corporate debtor has given an OTS proposal, that doesn't mean that the personal guarantor has also admitted its liability. So therefore, this particular application was rejected, being time barred, and the OTS proposal submitted by the corporate debtor would not be considered as kind of acknowledgement of debt of the personal guarantors also. So basically, what we can finally say that any OTS agreement between the bank and the corporate debtor does not mean that the personal guarantors are also acknowledging debt. The personal guarantors can still challenge the limitation. Now, another case which actually I found little more important is in the case of Sailesh Balachandra Desai. It is the 1st February 2024. It is NCLT Mumbai. And in this case also, NCLT held that under IBC, there is no bar on proceedings against each separate personal guarantors for the same debt. Dependency of CIRP or a resolution plan for the corporate debtor does not prevent against the personal guarantor. Even if the CIRP is concluded, even if the resolution plan is approved and implemented, that does not make a case that the personal guarantors are relieved from their responsibility or released from their responsibility. The limitation period that actually can be seen separately in the case of personal guarantors, but the only conclusion is the corporate, whether the petition to initiate CIRP against the personal guarantor that it was filed, again, the limitation period is separate. Limitation is separately seen, even if the CIRP is concluded. So, Ankit, we can take some of the questions that actually are important, but then I actually would like to say there are a couple of other things. Normally, there is a confusion nowadays that whether there is a report which is required or not. So, whether there is a report which is required or not. So, I have the latest amendment which actually we have seen that the IBBI has made on 31st of January 2024. In these amendments, one clarity that anyone who has worked as RP or liquidator in the case of corporate debtor, the same person can also be appointed as RP or as bankruptcy trustee in the case of personal guarantors, insolvency or bankruptcy. And another is the regulation 19 was in fact changed, and that is also a kind of confusion that if the resolution professional, the first of all, the regulation 19 says that the resolution professional shall file the repayment plan as approved by the creditors along with the report mentioned in section 106 or 112 as the case may be with the adjudicating authority on or before completion of 120 days from the resolution process commencement date. So even if there is a repayment plan or not, the RP is under obligation to file a report within 120 days from the resolution process commencement date. Then when we see section 101 regarding moratorium, it says when the application is admitted under section 100, a moratorium shall commence in relation to all the debts and shall cease to have effect at the end of the period of 180 days, beginning with the date of admission of the application or on the date the adjudicating authority passes an order on repayment plan under section 114, whichever is earlier. Now, this is a very kind of a difficult situation that the RP has to file a final report along with the repayment plan or not within 120 days from the commencement. The moratorium section says, 101 section moratorium, it says that if the application is submitted under section 100, that means if the repayment plan is also submitted within 120 days and the 60 days time is also available with the NCLT for adjudicating on that repayment plan, accepting or rejecting that. But in case the adjudicating authority is not able to do within the next 60 days, then the moratorium would get extended or moratorium would be over. So because the moratorium is only restricted to 180 days as far as this debtor is concerned, but the RP has done his part within 120 days. Now the question is there is an issue which is going on with various banks, that some banks are saying that the RP's role is only up to 120 days, that is 4 months, because they want to pay the fee to RP only for 4 months. However, when we see the CIRP, in the CIRP cases or in the cases when the resolution plan is submitted, after even the resolution plan is submitted, the role of the RP is there, because he actually will be called to the office of the to the court when the resolution plan hearings are there or when other hearings are pending before the adjudicating authority. So the RP is continuously working as RP when the resolution plan is submitted or repayment plan is submitted. Technically, RP's role ends when the repayment plan is admitted or rejected by the adjudicating authority. If there is a delay by adjudicating authority, the RP will continue. Because see, a resolution professional is submitting the report, but then when a resolution professional is discharged from his obligation, the resolution professional is discharged from his obligation when the moratorium is lifted or when the repayment plan is accepted or when the repayment plan is rejected. So therefore, saying that the RP is only working till only 120 days is not really correct. So the responsibility of the RP continues till the time the repayment plan is accepted or rejected and the CIR and the insolvency resolution process is over. So that is the one clarification that I wanted to give. The moratorium is restricted to 180 days, even if there is a delay in adjudication. RP's role only till filing the repayment plan is not there. RP role continues because even after submission of the repayment plan, RP would be parties to all kind of objections, all kind of applications which are being filed by anyone under this case. So the RP's role continues till the time finally the insolvency resolution process is closed. So Ankit, we can take some of the questions which are in fact maybe important, but then you can actually see if there is any other interest.
So I will start taking the questions one by one. So Uttam Tekribalji is asking that can PG insolvency be filed before CRP is completed, and how will the amount be determined? So it can very much be filed. Rather, the intent is that if the CRP is going on, the PG insolvency will be filed before NCLT as per the jurisdictional requirements. And also the amount in case of any guarantee will always be the outstanding amount unless and until the guarantee is capped with a certain amount in some cases. But otherwise, the full liability that is due from the principal borrower is also due from the personal guarantor or the corporate guarantor. This is how it works. And if there is any recovery from any other source, then the amount due can be revised at that event. That is how this works.
Absolutely. Absolutely.
Then Adanki ji is asking that RP needs to accept the claim from FC. Does he have powers to reduce the claim amount? So the powers to reduce the claim amount are restricted to verification in case the FC is not able to give evidences of the amount which is outstanding towards him from the personal guarantor. Then the claim can be reduced, but there cannot be any adjudication of any dispute. It can only be verification based on documents. I think that is the restriction.
Yes, I think the claim verification is a process which actually is the similar to what we have seen in the liquidation or we have seen in the CIRP. The RP has the power to verify the claims based on the evidences submitted along. So basically, the proof of claim is most important. If the proof of claim is acceptable, the claim is acceptable. If the proof of claim is not acceptable, then the claim can be rejected or partially rejected.
Then Hari Prasad ji is saying that while hearing RP report under section 99, PG is allowed to raise objections on the RP report. PG raises objections on guarantee documents, etc. So who has to reply to the objections, the RP or the FC?
No,
RP will have to say that the basis of the report is these sources, right? And then if the FC is the source for that information, then he will have
okay,
to
so there
say
are
that.
three parties. In the one is the applicant, that can be a creditor, and then is the debtor, personal guarantor, and then is the RP. Because the RP has submitted a report and copy has gone to the debtor as well as to creditor. So if there is any objection which is to be handled by the RP will provide the reply. And if there is any objection which is regarding the guarantee document or the amount of the loan, then even the creditor can also respond.
Then we have Kedari Narsimha ji. He says that please advise how to address the practical issue of taking care of RP's interest in terms of fee for the intermittent period starting from the submission of the report and so on. And then as per the current practice, the petitioner is agreeing with RP for a fixed fee for Section 99 report and the monthly fee starting from the date of admission of petition by Honorable NCLT. This intermittent period is left out and the RP has to attend NCLT proceedings, etc., without getting paid. So yes, this fee system I think is something that many RPs are bothered about because it sometimes feels that the RP is having to make more efforts than the remuneration. So I think that's how sometimes we understand the scope of work and then quote accordingly. So if this is looking like more time is invested in the whole process, the fee for that period will automatically go up. Bankers perhaps or those who are applying for personal insolvency will not get professionals who are willing to do this job for this fee. I think that is how it will change.
So presently, what is in vogue is the 1 month fee for preparing Section 99 report and then finally appearing all the hearings, equivalent to 1 month fee. And then the next is when the insolvency resolution process starts. Now, when the insolvency resolution process starts, some banks are saying that since you have filed the report and then along with the repayment plan or without the repayment plan, so your role finishes. That's not the right way. The right way is because once you file the repayment plan or file your report, the entire adjudication on the closure of the insolvency resolution process also it has to be attended to by the RP. So I think till the time the insolvency resolution process finishes, it has to be the fee has to continue. So since it is see in the case of CIRP, the fee is supposed to be paid from the funds of the corporate debtor, or in case there is no fund, then it is a contribution which is interim finance, and that will go back to the lenders. So in the case of personal insolvency, the fee will be paid by the applicant unless there is a repayment plan. And if there is a repayment plan, then the debtor will pay that fee, whatsoever fee is applicable to that case. I think the MD also IDRCL has raised hand. I think we can seek the indulgence of.
Just give me a second. Yes, Anilji, if you can unmute yourself.
There's another request also. Yes, please.
Good morning, sir.
Good morning.
This regarding OTS proposal submitted by the personal guarantor itself to the creditor will not be considered as admittance of the liability?
It will be considered as admittance of liability. It will be considered as acknowledgement of debt. So the limitation period will be over.
Okay. Because earlier you said the OTS proposal sent by the financial creditor will not be considered.
No, OTS proposal submitted by the corporate debtor, that would not be considered as acknowledgement of debt by personal guarantor. But if the OTS proposal is submitted by the personal guarantor, that will be considered as acknowledgement of debt by the personal guarantor.
Fair enough. Thank you.
Even if the OTS proposal, which is regarding corporate debtor, even if that is signed by the same person who has given the personal guarantee, that will not be considered as acknowledgement of debt of the personal guarantor. Even
Oh,
if that OTS
okay.
proposal is signed by the same person who has given the personal guarantee, because that is with respect to the company, that is not with respect to the personal guarantor.
Agreed. So he has to give, the personal guarantor has to give his own proposal for that OTS.
Yes, he can still give own proposal for the. In case he gives his own proposal for OTS, then it will be considered admittance of debt.
Thank you. Thank you.
Then we have the next question that I can take up is that Ravi ji is asking that the lenders, while asking for a quote, is asking us on how much period the process will take and capping the fee for that period only, whereas NCLT is taking 3 to 4 months for approving the Section 99 report. So sometimes HCs are giving stay, high courts are giving stay, and the period becomes uncertain. So again, irrespective of, I think we all understand from our experience, so we can vote based on our renewed understanding of how much time it takes.
Gradually, gradually this work under the personal insolvency of personal guarantors is increasing. Earlier, there was no provisions for serving the copy of Section 99 report to all debtors and creditors. Now there is a judgment that it has to be also shared with them. Then they also have, as a natural justice, this Dilip B. Jeev Rajka judgment of Supreme Court says that it is the natural justices that they can actually say whether they can also have objections on the report under Section 99. The involvement of RP is very high. The RP is also supposed to appoint lawyers and brief them for every hearing. And even after the repayment plan is submitted, the RP role continues. So the banks are saying that the RP fees will only continue only 120 days. That somehow is not acceptable. Yes, the RP, even if in this particular case there is no custody of the assets and there is no even asset tracing which is required, but the information has to be sought from the debtor. The repayment plan has to be prepared in consultation with the RP, and RP has all the rights as per the judgment of Surendra B. Jeev Rajka versus Omkara, where the RP has a right to seek information from the debtors for the purpose of preparing a report under Section 99. And also during the insolvency resolution process, the RP has a duty to seek the information about assets and liabilities of the debtor so that appropriate repayment plan can be prepared. Because in the repayment plan, there's a lot of detail which is required to be submitted as per the regulations specifically made for personal guarantors. So for all that information, RP has to work very, very closely with the personal guarantor so that all the assets and all the liabilities are captured in the repayment plan. So therefore, the role has actually increased a lot now. Therefore, the fee that originally that we thought that not much of work actually is now the fees which is actually in the market is much lesser than it is not commensurate with the work that the RP is supposed to do.
I think Anilji wants to say something as well.
Sir, there are two questions. One, some of the benches are requesting or rather insisting that RP to argue. RP should not be hiring legal counsel for personal insolvency cases. What is your view on that?
No, I think this may be very, very specific to some of the benches. And the bench normally they don't bother about who is paying. They only see that who actually is talking sense in front of them, who is saving their time. and in case the RP is well versed and the RP is saving their time as compared to the briefed lawyer, then they will say, okay, RP is better. But then as far as the benches, they cannot say that the only RP has to argue, not the advocate appointed by the RP.
No, sir.
They only see who actually can save their time and who is actually coming directly to the point.
No, sir, I don't want to mention the name, but the principal bench, with due respect to that, they have many times they have said RP to argue, and RP should be ready with the notes and why the counsel is speaking. I am being very precise now.
To some extent, I would also say that RP is the person who has the most knowledge about a case, and all these cases, in case it is the argument is based on facts, then the facts are more with the RP rather than the lawyer, unless it is properly briefed. But I think the individual choices may differ from bench to bench. But as per law, the court has all the rights to say that yes, they would prefer first-hand information, or they would prefer the information from a lawyer. They have all the rights to say.
Okay.
Then we have next, we have also Raviji raising his hand, and we also have Mikul Siva Mohanji. Mikul Siva Mohan.
Sir,
Yes, sir.
this is regarding the personal appearance, what he was saying. In some cases, what happens is that I am in Bangalore, but the RP may be from Bombay or any other place. We can't say that. No. So if the bench says that let him appear personally, means that itself will be a big challenge. So how do we?
No, see, personal appearance of the RP through virtual mode or physical mode, that is very, very personal behavior of a member of the tribunal. Whereas if somebody say that I want to hear from the RP, that is their prerogative, and that can be met even if they hear the RP virtually. They should not say that the RP must come personally unless they find that the RP is not able to explain virtually. As I said, that the court has all the rights to choose whether they want first-hand information or they want briefed information. The court has all the rights to say that this is a complicated case, so rather than a virtual hearing, we would like to hear it physically. So I don't think it can be challenged, especially when it is specifically said to someone that we need to hear this case physically because of the complication and because of the multiple people appearing in the case. So that is the right that they have, and it is not really possible to challenge that right. But virtually or physically, and that is something that the right that RP has. If you go to IBBI, and IBBI will say that if you have appeared virtually, that you have complied to your obligations. However, if there is an order from NCLT that you have to appear personally, and then you have not appeared personally, physically in front of them, then it is a non-compliance. So unless there is an order where you are supposed to present physically before the court, I think your presence virtually would be considered as compliance to all the rules and laws.
Sir, may I?
Yes,
Yes.
please.
Sir, as far as my case is concerned, the personal guarantor says that it's not possible for him to give a repayment plan. He says all the assets have given to the creditors and almost it's already sold. So in that case, what should be my report? Do I need to give a prayer? Because I'm going to say that this is what the personal guarantor says, that he has no assets and everything, whatever he had, he has already given to the creditors. So what should...
when your report goes, because see, earlier there was an option available with the RP that if there is no repayment plan, the RP may or may not have the meeting of the creditors.
Okay.
But now from 31st January 2024, the IBBI amended the regulations, and IBBI made it mandatory for the RP to have a meeting of the creditors. Even if there is no repayment plan, the meeting of the creditors is must now. And
Yes.
that so the report of that meeting has to be submitted to adjudicating authority within 120 days from the date of commencement of insolvency resolution process. Now,
Okay.
in that report, there is a format that what you have to report in that format, and you have to prepare that report and submit it. So NCLT, then they would close the insolvency resolution process. And in case they still say that this report, the RP should have done some more exercise, so they can always ask you to have some more information gathering and then come again and file another report. But that is not happening in many cases. So the bench will close the insolvency resolution process on your report. But your report must say what you did, how the claims came. So that means that the liabilities, you have the details of the liabilities. Then
Yes.
the bankers also can give you additional information regarding the assets which are mortgaged to banks, and the banks have not relinquished those assets in favor of the RP. That you can also mention. But in case the banks have already sold those assets, that also you can mention. So that is the kind of report so that the adjudicating authority is convinced that there is nothing left in this case, so the bankruptcy can be started.
Okay, sir. Okay,
Good
sir.
morning.
Thank you. Thank you so
Well,
much.
Ankit ji, I am Subhrata Ghosh from Kolkata. Sir, I have one question regarding PG. If he is or she is absconding, Section 99 report has submitted, including that traceability is the questionable. Report note is there. What should now the adjudicating authority and RPU will do for this type
See,
of cases?
there are cases. In fact, in one of our case, ST Aluminium, that person in fact had gone abroad and he has taken the nationality of Singapore. No, he said to the court that no, I'm not a citizen of India. So the no proceedings under this law of India regarding personal guarantors can be initiated against me. And finally, the NCLAT held very clearly that the personal guarantor, the proceedings against the personal guarantor is not subject to whether he is a citizen of India or not. He has given a loan, he has given a guarantee to the loan in India. The loan was given to a corporate debtor in India. So there is a default. So therefore, the all this can be done. The proceedings against the personal guarantor can be done. So then
In case of India, it is not known whether he has or she has gone to abroad or staying in India. Just she is not traceable. Then what to should?
Then this report under section, like as I said, that the report under section 106 has to be submitted by the RP. In that report, you will mention everything, and the insolvency resolution process will be closed, and the bankruptcy process will start.
Okay,
So
that is the only way.
There is no other obligation to the RP. If the debtor
Any
is not
other
coming,
publication, newspaper publication for absconding or finding out?
no, but that is not your role. That is not your role. You are not doing asset tracing. Bankruptcy trustee will do asset tracing. You are not doing custody and control of the assets. You are not taking the control on the bank accounts of the debtor. The insolvency resolution process is only a process where they want to resolve. The bankruptcy is a process which everything is required, even the avoidance transactions, even the tracing of the assets, taking custody control, avoiding his tours to abroad. All this is only and only when the bankruptcy starts, not before that.
Is there bankruptcy is already notified?
Yes,
So
yes,
that
yes, very clearly, very clear.
any result?
There are many cases of the bankruptcy already started.
Okay. So in that case, we have to do notification in even this type of cases. If I am again appointed as a
In
bankruptcy
case you are
trustee.
appointed as bankruptcy trustee, which you will be, because see, the law says that you would be appointed the bankruptcy trustee in case you acted as RP.
Okay, sir.
Yeah. However,
Thank you.
separate application is required for bankruptcy, maybe from the debtor or from the creditor. It is not automatic.
Okay.
The application is supposed to be submitted within 3 months of the closure of the IRP process.
Okay. And then we have to search for that. Any help from administration like CBI or local police for searching out or finding out?
Now, see, like it's the way we have regulation 30 in the CIRP regulations, we also have similar powers where we can actually approach in case we identify an asset and we are not able to take the control and custody, then we can file an application to NCLT. NCLT will direct the local administration, and the local administration will help the RP to take control and custody of that property. That would be there in the bankruptcy trustee proceedings.
Okay, sir. Thank you, sir. Thank you, Goelji.
Yes, please. So one scenario, Ankit, I wanted to say, because there are many cases which has actually been dropped by NCLT because the bank guarantor, because the personal guarantor has died or personal guarantor is no more. So therefore, the NCLT has passed many orders that there is no insolvency resolution process can start. So I definitely want to bring in the light section 169 and section 170 of the IBC, which very clearly says continuation of proceedings on death of bankrupt. Now, the insolvency resolution process is completed because there is no, that debtor is not there. But the bankruptcy process has to continue. Now, the bankruptcy process actually 169 and 170 says it has to continue. It is not something that the estate of the bankrupt is responsible for meeting the debt of the deceased. In many cases, probably the bench has ignored these two sections. Bench, while closing this IRP, insolvency resolution process, should have also directed that the bankruptcy process can be initiated against the estate of the deceased. So this is what I wanted to say. Section 169 and 170, that should be read, and the bankruptcy can be started against the deceased guarantors.
Right. Any further? I think there are still some raised hands if anyone want to say something.
Okay, if I may be allowed, we have been discussing about the role and the Lakshman Rekha of the RP. So, like, the asset tracing is he cannot, press upon.
Yes.
Yes. So how an RP should, continue with that, ascertaining what exactly remain with the personal guarantor, including that of, from income tax returns or everything. If you could guide us, sir, this, so that Lakshman Rekha is not crossed, or we are also in a right path to, which helps us to file the report under section 106.
So that 106 report, and in fact the repayment plan, in case no repayment plan is submitted, there are many cases where even the debtor has not even approached the RP. The RP has never been able to establish a contact with the debtor, but the RP has to close it, and the most kind of coercive action will start during bankruptcy process, not during insolvency resolution process.
Okay.
Law is very clear that insolvency resolution process is a kind of mediation, and a repayment plan can be drafted in consultation with the RP, considering the assets and liabilities of the personal guarantor. Now, considering the assets and liabilities, whatever best you can do to find out the assets of the debtor, that is within your scope of work. In case you can go online, in case you can, because I have, I met a person and he has a kind of a software that he developed. He says, and he claims that if you give me the PAN number of a person, and he will be able to find out any property registered anywhere in India on that PAN number, unless that particular property is registered at that time when the PAN numbers were not necessary. So then, in case you are able to find the assets of the debtor during the insolvency resolution process, and you are able to inform that to the creditors and to the debtor, then a repayment plan can be definitely worked out. Otherwise, the personal guarantor will always feel that in case the RP is not able to understand my assets, it is better. I will deal with when the bankruptcy will start. So in case anyone is able to find out the assets.
Sir, my apology. If I approach such a outside professional, will that not tantamount to, I am just going hard and pressing hard for tracing?
This is not, no, seeking information about someone is not coercive. But the only thing is that the fee should be approved by your applicant. Normally, the banks are not investing on all these efforts. you have to get the approval from your creditors, because from your applicant, the applicant bank, because this is the kind of cost that you are incurring. So whether they approve or not, but mostly the banks are not approving. They may approve during bankruptcy, but they are not approving during insolvency resolution process. So then using such kind of expensive software, which actually will tell you the any property registered in that person's name based on PAN, so that actually that can play a good role. But my only issue is that whether the money is invested by the applicant or not, that is a big question. The fee of that agency.
Sir, if you could share the name of agency, if that is within your.
No, I can. I will share separately, or even I can even see that I have that.
Sir,
No, I will share it. I will share separately.
If you permit me, actually, I raised my hand only to answer this query. Section 138 of the Income Tax Act provides that any court officer can go to the Commissioner of Income Tax and ask for details. Okay, so in one case I tried it, but subsequently they settled, so it didn't go further. But Section 138 of the Income Tax Act, RP can, because he's a court-appointed officer, he can approach Commissioner of Income Tax for details of a given PAN number, so that if you get the income tax return, you will know what are the source of income or that.
That is important. That is important, provided the income tax department.
Filing income tax returns, they'll have the returns copies.
Yes, certainly.
That should help.
Thank you very much, sir.
That is acceptable. That is acceptable.
So I have a question.
Any important questions I think we can see. Otherwise, I think the time is already up. We should maintain the timeline.
The last question I think I had put in also on the chat box.
Yes, please.
There is no cooperation from the PG for any information. And unlike during CRP, we could file a Section 19 subsection 2 application against the same promoter during CRP. But during personal insolvency is not cooperating again. So what can be done during personal insolvency?
As I said, that the role of the RP is only kind of facilitating the court and not kind of adjudicatory. So there is no requirement of taking control and custody of the assets. So whether the cooperation is coming from the debtor or not, that is depending upon the debtor's wish, whether the debtor wants to submit a repayment plan or not. So in case there is no cooperation coming from the debtor, that means there is no possibility of repayment plan. So you actually have to file your report under Sub 106. But I don't think the court will never ask you what all efforts you have taken to understand the assets and liabilities. As far as the liabilities are concerned, any claim that comes to you, you have to verify that you can already say that this is the liability. But as far as the assets are concerned, the courts will never say that you have not made any effort to unearth the assets of the personal guarantor. That is not considered as the duty of the RP in insolvency resolution process, but that is the duty of the bankruptcy trustee. At that time, the court will ask you what efforts have you made to trace the assets of the personal guarantor.
Okay, thank you.
So I think thank you so much, and I think it was a really interactive session. We still have 37 unanswered questions, but I think we'll have to take them offline. Thank you everyone for such a positive response for today's webinar. Thank you.
Thank you very much. It is our way of learning. Thank you.